Welcome to Decarceration Nation, a podcast about radically reimagining America's criminal justice system. You can find all previous episodes on our website, www.decarcerationnation.com. And if you like the podcast, please remember to hit like and to subscribe to the channel below. Lisa Hajjar is a professor of sociology at the University of California, Santa Barbara, whose work focuses on the relationship between law and conflict. Today we're going to talk to her about her book, The War in Court: Inside the Long Fight Against Torture. Welcome to the Decarceration Nation podcast, Professor Hajjar.
Thank you for having me.
Yeah, I always ask the same first question, the answer to which in your case could be particularly interesting. How did you get from wherever you started in life to where you were extensively involved in researching and even in a sense being a kind of direct witness to our government's involvement in extraordinary rendition and torture?
Well, I would say that my that journey began when I was a graduate student, and I decided to do my doctoral dissertation on the Israeli military court system in the West Bank and Gaza. And so, I had originally conceived of that project as looking at the way in which Israeli and Palestinian nationalisms clash in that setting. But when I got to the field to start doing field work, and it was 1991, one of the things I realized very quickly was the centrality of torture, Israeli torture of Palestinians, to Israel's larger control strategies. Because at the time, it's sort of on the tail end. I was starting my work on the tail end of the first Intifada, and the way in which the Israeli government had responded to that massive uprising against, protracted denial of self-determination was really escalating their already intense arrest, prosecution, charges in the military courts, conviction, and imprisonment. And torturing people for confessions was absolutely central to that whole process. So it really gave me the fascination with, the questions of torture and the law. But the other thing that really kind of positioned me well for what eventually developed, after 9/11 into my work on U.S. torture was the fact that Israel became the first government in the world to quote unquote legalize torture. Back in 1987, the government had decided to officially endorse what they euphemized as moderate physical pressure tactics in the questioning of Palestinians. And it was government lawyers who kind of provided the veneer for that rationalization. So one thing to say is that many governments torture, but only liberal or political liberal governments feel the need to try and justify it by reinterpreting the law. And so after 9/11, in the immediate aftermath of 9/11, when I was listening to things that U.S. officials were saying about how they were going to respond to the terrorist attacks and how they were planning to wage this new war on terror that begins almost immediately after 9/11, it became clear to me that the plan was to use violent and coercive interrogation tactics. And so it really made me, in hearing things that U.S. officials were saying, Cheney, former Vice President Dick Cheney, most obviously, about what was going to be done to people who would be captured, I could see that the United States was planning to emulate the Israeli model. And so that was really, I'd say, so I was looking for signs of U.S. torture long before those signs became public. And that's sort of like the seeds of the book that, 20 years later, I published.
Yeah, before we kind of get more deeply into the book, in the book, you kind of mentioned another precursor, which was a U.S. program called the Phoenix Program during the Vietnam conflict. I wasn't familiar with that one. I was a little more familiar with the Israeli example. Could you talk a little bit more about that program so that everybody kind of gets that context too?
Sure. Well, in the context of the Vietnam War, the Vietnam War was the first major war that the United States was involved in the 20th century. That was really what they call an asymmetric war, or at least the government was characterizing it as an asymmetric war, meaning that the U.S. military was fighting against unconventional enemies. I mean, the North Vietnamese, was obviously a conventional enemy, but it was the Viet Cong, supporters of a unified Vietnam and supporters of Ho Chi Minh and North Vietnam in the South were, sort of engaged in the war as unconventional fighters, not wearing uniforms, etc. And so one of the program, the Phoenix program, was developed in order to do what often happens in asymmetric wars, where a government needs to gather what they call human intelligence, like the intelligence from human beings about things that are, not otherwise detectable. So when you're fighting with an unconventional enemy, there's not, massive troop mobilization or things that can be spotted through aerial surveillance. It really depends on interrogating people for information. And so the Phoenix program was basically run by the CIA, with that, sort of the collusion of South Vietnamese police. And it involved, like capturing people and brutally interrogating them for information about Viet Cong activities in the South. And oftentimes people would just basically be tortured, so brutally. And then when the interrogations were done, they would be killed, so they were then extrajudicially executed. So about 27,000 people were killed as a result of the Phoenix program. But as often is the case, when a government is relying on torture, for information, it doesn't actually work. It's an idiotic presumption. And, as we all know, the United States lost the Vietnam War. So that was, it's a very dark stain, but it was a precursor, because someone like Cheney, who really comes of political age in the 60s and 70s and was very hostile to the kind of post-Vietnam reforms that were instituted to prevent things not only like the Phoenix program, but also like COINTELPRO, where the FBI would spy on anti-war activists and civil rights leaders and so on. Cheney was very hostile to those kinds of efforts to rein in the state. And so what happens, after 9/11 really provided an opportunity for Cheney and a small circle of lawyers around him to really reboot the power of the executive branch. That is to like kind of shuck off the kind of oversight mechanisms that have been instituted in the 1970s and 80s, and to kind of like bring the United States back to where the executive branch could operate without much oversight and at its own discretion.
And you talk about Cheney. So we're attacked on 9/11, and the administration, particularly Cheney, decided that the war on terror should be kind of a different kind of war, one in which we heavily invest in arrests, detentions, rendition, torture, or I guess what they would call enhanced interrogation. What do you think caused the shift in their minds, or is it just something that Cheney was always committed to? Do you think there was anything that created this shift?
Ignorance. Cheney was ignorant. I mean, like there's no, like, he and the people around him, that sort of echo chamber, know nothing about what actual effective interrogation involves. And effective interrogation does not involve torture and violence. But they had deluded themselves or persuaded themselves into thinking that these nefarious enemies, Al Qaeda and others who were, sort of the unknown enemies. I mean, that's also part of the issue is when the United States began the war on terror, they didn't actually know who they were fighting or what they were looking for. But there was this hubristic assumption that, that violence would work, and that, anybody that we caught and put into interrogation in Bagram, or then soon thereafter shipped off to Guantanamo, must be a terrorist. And the only way we could get information from them must be through degradation and violence. And then, the logical assumption of that kind of ignorant posturing is that anything they would say would then become true. And when you're using torture, you don't actually know if a government needs to rely on torture, they don't actually know what the answer is. So when you torture people for information, there's no way to judge whether what is being said is true or false, whether people are saying things just, sort of following back on the kinds of questions they're asked and telling their interrogators what they think those interrogators want to hear, just to make the violence and the pain stop. So, the whole origins of the war on terror was basically a hubristic ignorance, and that's what really drove the torture policy. And I would also add that it was, in order to, make a government policy based on ignorance and hubris, they had to actually cut out all the experts. And that was something Cheney was very comfortable doing, was excluding, military lawyers, from the discussion of military interrogations and so on. So it was it was a witch's brew of, of
Yeah.
horrors.
Unfortunately, that's been somewhat of a precedent that's been followed in future administrations
Yeah.
after.
Yeah.
Uh, so, when we talk about torture or enhanced interrogation techniques, what was included under the penumbra of enhanced techniques, at least post 9/11?
Okay. So the strategy that people, once they decided they were going to engage in violent, authorized violent interrogation tactics, what specifically happened, like the real kind of framework for what was developed first by the CIA and then spread to the military, was just to provide a little bit of context. Well, if we can go back to the Korean War, for this context. So during the Korean War, one of the things that happened, was the shocking speed at which American soldiers who were captured by North Korea or China were basically broken. Like they would make false statements and so on. And so after the war, the military did, sort of really did a study of these former American POWs to understand both what had been done to them and why they had broken so quickly. And so the mechanisms that the Chinese used were not really physical beatings. It was different kinds of ways of really attacking the psyche of people. So stress, I mean, it wasn't unphysical, there were physical aspects, but it would be degradation, protracted isolation, and so on. So after the Korean War ended, the US instituted a program that was originally targeting just like elite Air Force members of the Air Force who might be captured by governments, shot down and captured by governments that don't respect the Geneva Conventions. And so the program was called Survival, Evasion, Resistance, Escape. It was the SEER program. And the SEER program, which was first for the Air Force, but then it expanded to all four branches of the military, was designed to train US soldiers to withstand certain kind of torture techniques, waterboarding, and other kinds of techniques. And so after 9/11, the idea was to, quote unquote, re-engineer those SEER techniques. So to actually authorize US CIA and military interrogators to use the tactics that had been identified by the government as torture tactics that US soldiers had been trained to try to withstand. And so the SEER tactics were really the framework for the violent and degrading tactics that were then authorized first for the CIA and then for the military.
And at the center of that, the people who came up with the SEER, that's Bruce Jensen and James Mitchell, is that right?
Right. They were the two psychologist contractors. So they had been SEER trainers. That was their big claim to fame, was that they had run a SEER training program. So they'd trained US soldiers to withstand these, kind of tactics. So when the CIA decided to hire them very early on in the, after the start of the war on terror, when the CIA was already planning to embark on its own rendition, detention, and interrogation program. And so these two psychologists, James Mitchell and Bruce Jessen, sort of went through all the SEER techniques and then proposed those within the larger collection of techniques that they thought would be most effective for interrogating, alleged terrorists that would be in CIA custody. And so a number of those techniques were then approved, and then Mitchell and Jessen basically ran the CIA's black site torture program.
And is there a way to kind of quickly go through the different forms. I know you kind of generalized the. I just want to get people. I want people to understand what we were actually doing.
Okay. So it would be, sort of a number of, I mean, like sort of the most physical techniques would include waterboarding, in which someone is strapped to a board with their head, feet slightly higher than their head. A cloth is placed over their face. I mean, they're completely bound on this board, and then water is poured onto the cloth on their face. So the cloth intensifies the sensation that they are being drowned. Like they are actually being drowned, but they would, so that was one technique. Other techniques would be, like I said, protracted isolation, forced nudity, other forms of, sort of humiliating techniques. But also another physical technique is walling, and that was one that was very popular with Mitchell and Jessen, was where, as they ended up practicing it, they would bind a towel around a detainee's neck, and the towel would be attached to some kind of a rubber cord, and then the detainee would be smashed into the wall and then jerked back. So the towel would like pulled up, so they'd hit the wall and then be jerked back. So that walling, the effect of walling was to create sort of an intense shock as well as physical pain. So those were, some of the main techniques that were used in the black sites. And again, those techniques that were approved for the CIA in August of 2001, with the sort of blessing of the Justice Department's Office of Legal Counsel, and specifically someone who was close to Cheney, someone named John Yoo, who was the Deputy Assistant Attorney General in the Office of Legal Counsel from 2001 to 2003. And so he was the guy who would write the legal memos basically sanctioning the kinds of practices that Cheney and his own legal counsel, David Addington, favored. So that those tactics were given their legal blessing in a memo dated August 1, 2002, and for the CIA. Now, the CIA is a civilian agency, so the CIA isn't bound by the Geneva Conventions. The CIA, we can talk about the CIA till the cows come home, but the military is bound by the Geneva Conventions, although the idiots around Cheney thought that the president had the power to just decide not to abide by the Geneva Conventions. So that approval that was authorized for the CIA was then turned by the White House over to the Pentagon, and Secretary of Defense Rumsfeld seized upon it, and then basically that became the basis for the approval of torture techniques at Guantanamo. And then, of course, those techniques, as we know, then migrate to, they both were sort of being practiced in Afghanistan and Guantanamo, and then they ended up migrating to Iraq after the US government invaded Iraq in March of 2003.
And do we have any idea approximately, obviously we will never probably know the total truth, how many people were detained and interrogated?
Oh, by the military, there's, it's like tens and tens of thousands of people. I mean, we do know, so like from between Afghanistan and Iraq, that's like tens or even 100,000 people. I believe that the number for people who were disappeared into CIA black sites or somehow caught up in the CIA program, I believe the total number, because that was the basis of the Senate Select Committee on Intelligence's investigation, that started in 2009. I believe there was 119 people ultimately who were held by the CIA in black sites, and there were 780 people. That was the total number of people detained at Guantanamo. But, really tens of thousands in Afghanistan and in Iraq.
Yeah, and so is there anything to distinguish between the kinds of facilities where people were kept? And in a sense, what caused one detainee to be kept at one facility and another person at a different kind of facility or whatever? Why were some people in Gitmo and some people like in Egypt or whatever,
Okay. Well, that's a good question. So there's three parts. So one is that the CIA was thought itself, equipped to identify who would be the high value terror suspects. So they were basically going not after like the Taliban foot soldiers or whatever. They were trying to figure out who were the real terrorist masterminds or people who knew about terrorist networks and so on. So they were basically trying to go after those that they assumed would have like very valuable information. And so the people that were captured by the CIA, like one place that they would be held in black sites, and there were about, I believe, 11 black sites, which are basically secret prisons in other countries that the CIA itself ran. So we know that in Europe, there was, the CIA had black sites in Romania, Lithuania, and Poland. And then they had them elsewhere. There was a black site in Morocco. There were several black sites in Afghanistan. That's one place. So those black sites were really, I mean, there's a variation in what the black sites were like. But the question of why, the third dimension of the CIA's rendition, detention, and interrogation program, RDI program, is the rendition. And so it was decided, like if some people, it was decided, some people that the CIA either wanted or had, they would send either to that person to his or her, his own country, where like the local interrogators could, perhaps get information that American interrogators couldn't get, or, specifically countries that have notorious records of torture. So the U.S. War on terror was reliant on the torture by other regimes. And so Egypt was one of the popular spots where people would be rendered into Egypt, tortured by Egyptian interrogators until they said something that might be of value, and then they'd be shipped back to the CIA, into CIA custody. Morocco, Jordan.
So part of this is because we had these techniques that we were using, but we had allies that were known for going farther, and so.
Yes.
In some of these places, if we wanted to send someone to really get, we would send them to one of those places. Is that
right? Absolutely. Yes.
So, yeah, that's disturbing. I guess I knew that, but it's still disturbing to hear. Your book, though, is really kind of about how the legal and, in some cases, academic people opposed to the torture program started to rise up. And these people kind of were opposed to the people in favor of torture, and they kind of were in a battle over what law means. Can you talk about some of what you learned from being a witness to this kind of conflict? And we'll talk a lot more specifically about it, but just kind of an overview real quick.
Okay. So the way in which I like my book, it's written for general readers. So it's sort of traces and tells the stories of this long fight against torture. But so, early on, I mean, it was no coincidence that the people who were really making policy, Cheney and his legal counsel, David Addington, and they surrounded themselves with a small group of right-wing lawyers, because in a fashion similar to what I was suggesting about Israel, when a country regards itself as a liberal democracy, there's some need to justify what is being done in terms of through the law, even if the law is completely misinterpreted and twisted into unrecognizable forms. But so many of the policies that were instituted early on, the first one was the idea of being able to hold terror suspects incommunicado. But all of these were rationalized through by lawyers. Like it was sort of rationalized as a kind of legal prerogative of the president to do these kinds of things. And so the first real significant development in all of this was on November 13th, 2001, when President George W. Bush issued a military order. And that military order had actually been written by David Addington. And that was the order in which he decreed that any foreigner taken into U.S. custody overseas would have absolutely no rights, that they could be held incommunicado, they could not challenge their detention or their treatment in any court anywhere. And it was also in that November 2001 order that Bush decrees the existence of military commissions for those people that the U.S. government might want to prosecute in the future. And so that was a very significant thing. And so one of the, some lawyers, who were human rights lawyers and others who read, the reporting about this military order were getting concerned. But then it was when Guantanamo was selected as the main site for long-term detention and interrogation. It was selected on December 26, 2001, and the first detainees were airlifted from Afghanistan to Guantanamo. That's the U.S. naval base on the south side of Cuba, on January 11th, 2002. And it was basically said that these people were going to be detained incommunicado. The public could not know who they were or how they were being treated. And that was really the trigger for the first very small group of lawyers who basically decided to fight the Bush administration. And they didn't know what was happening at Guantanamo or how people were being treated, but they basically challenged the president's authority to have the power to, secretly detain anyone at Guantanamo. And so that was really the first legal challenge. In that case, they did find the names of a couple of people because they were the citizens of U.S. allied countries. So 3 of the people whose names these lawyers, Michael Ratner was the president of the Center for Constitutional Rights. He was really the driving force in this, and he was joined by 2 death penalty lawyers, Clive Stafford Smith and Joe Margulis. And so they did know the names of a couple of British citizens, one of whose names was Rasul. And so when they filed this first case, just challenging the president's authority, the case was called Rasul v. Bush. And so that was really the first legal challenge. But so you asked, why was it lawyers? Because the US government was framing what it was doing as somehow within the legal rights of the president or of the state, it required, they asserted a kind of legal rationale. It takes a lawyer to fight a legal rationale. So that's one of the big takeaways in my book, is that it had to be lawyers because of the way these policies were framed. It had to be lawyers fighting the legal interpretations of the state. And so that case was really the sort of opening salvo of what I then described throughout the book as the war in court.
Well, maybe it has to be lawyers, but we were at a time then where basically almost nobody in Congress stood up against this, against Iraq or Afghanistan, where, the Patriot Act and other things were passed almost unanimously. You have these attorneys, you've got the government saying these are the worst of the worst. We've been attacked. There's massive emotion on the side of doing whatever is necessary to protect our country. And so, this is not an easy choice for these lawyers. So, is there something is it just that there's a certain contrarianism, or is it that they just believe so much in the ideas that they're defending, or what, as in some of these people, what was your kind of feel of how they got to the place where they were some of the only people standing up against the government doing these things?
Well, one thing I would say, that's an excellent question. One thing is that, the policies that were instituted, the United States has many, many dark chapters in its history, but the policies that were instituted by the Bush administration were unprecedented, particularly secret detention and coercive interrogation techniques. Those things were never, the United States government has engaged in that kind of behavior, but it had never been really authorized as policy before. And so, just the first thing, the idea that the government can secretly detain people and not give them any right to challenge their detention. What if it's the wrong guy? That is one of the cornerstones of liberal legalism. It's it originates with the Magna Carta, the idea that, habeas corpus, a regime cannot secretly detain people. And so the fight began as a fight to defend this bedrock legal principle of habeas corpus. That was one of the reasons. And in fact, many of the events that ensue and the way in which more lawyers got involved was when that particular case, Rasul v. Bush, it loses in the lower courts because US courts are just not, inclined or had no experience thinking critically and realistically about a policy the executive branch had authorized that had no precedent in US history. And so the courts were just like, we're just going to dismiss these cases. But when it did get, Rasul v. Bush did get to the Supreme Court, Michael Ratner and his band of rule of law defenders won, and it was that is one of the major events that and there's many other things that occur right in the build up to that June 2004 Supreme Court decision, but that's when hundreds of lawyers who have become angry at what they were learning about what the government had done, including the secret authorization of a torture policy. That's when you get hundreds of lawyers volunteering to represent Guantanamo detainees as habeas counsel.
What's interesting there is, I think I want to talk about this a little bit, is the notion that it's really not, you may believe the law means something. I may believe the law means something. The lawyers you're talking about on one side believe the law means something. The lawyers on the other side either believe or are bad faith actors arguing that the law means something. And this kind of reminded me, and I think to some extent the book maybe is about this, is, many decades ago, I think back in the 80s when I first came into contact with this, was this notion in critical legal studies called the indeterminacy thesis. And Michael Dorff explained it as, if the application of a rule requires deliberation about its meaning, then the rule cannot be a guide to action in the way that a commitment to the rule of law appears to require. Similarly, if the content of a constitutional right or other constitutional provision can only be determined by extensive deliberation, then the Constitution does not enrich rights or other principles in the sense of providing foundational assurances. Indeterminacy opens the way to judicial discretion, and both the law and the Constitution are meant to be the master of those in authority, not the servant of their caprice. And I think in this instance, it's kind of an example of where we have hopes for what the law represents, but the law can technically be all of these things in a way. I think people like Dick Cheney, John Yoo, and other people in the Bush administration, what they were doing with torture, and to some extent later what Trump and Bannon were doing with democracy, is explicitly exposing the indeterminacy at the heart of our law and trying to exploit it. I know this is a really long question.
Yeah.
But,
well,
what is it really just a matter of interpretation and who is doing the interpretation? Is there can we believe that there's a core of law that is true, that there's something determinate at the heart of law? It seems like we want to believe that, at least the people who are arguing against torture want to believe this, but I'm not entirely sure that's true. Maybe it is, maybe it's not. What do you think?
Well, that's an excellent question, but there are two things that are absolutely and incontrovertibly true. Torture is absolutely a non-derogable right. Like no one under any circumstances anywhere has a right to torture. So any efforts the government did, the US government didn't say we have the right to torture. They said torture is bad, but waterboarding does not rise to the level of torture, therefore it's not torture. So, but torture is categorically, I write about this, torture is my thing. So I basically say like the right not to be tortured is, along with the right not to be enslaved, the most universal right that human beings have, because absolutely under no circumstances does anyone have a right to torture, and every single human being has an absolute right not to be tortured or enslaved. So that's one thing.
That's not entirely true, because the Constitution creates an exception for slavery in the 13th Amendment for people who are incarcerated. But yes.
Right. Yes, exactly. That can be like some of the, the civil, slavery. But the other, sort of bedrock thing, as I had mentioned before, was like that secret detention is unacceptable under all circumstances because it violates, habeas corpus, and habeas corpus is basically the idea that the state can be limited by law. But what Cheney and the circle of radical right-wing lawyers around him were pushing was another legal interpretation. They were basically latching on to this thing called the unitary executive thesis, which is a right-wing understanding of presidential power based on Article 2 of the Constitution, and basically saying that, Cheney and those around him believed that it would be unconstitutional So they're making a constitutional argument that any effort to limit or restrict the president's discretion on matters of national security or foreign affairs would be unconstitutional. So in other words, whatever the president wants to do must be legal because of the nature of his power under the Constitution. And therefore, so that was their effort to kind of negate the applicability of the Geneva Conventions and other laws. So it's a legal argument to open up space to do illegal things.
That kind of makes me think of two things. The first thing is that if it's true that if they had won the argument that the unitary executive theory was true, if the courts had upheld that, would that not then bring into question the premise that torture is absolutely can't be done? Because if the president can just imagine it away, it didn't win the day in this instance, but it does seem to be an example of what I'm talking about the indeterminacy of law, that there are contradicting impulses within the Constitution that may indeed mean that there is, the emperor has no clothes at the heart, if that makes sense.
Right. Well, I mean, so one of the things, and since I'm not a lawyer myself,
Yeah,
but
me
one of the
either.
things that I learned, through the this is
I
what
like to play one
scholars
on podcasts.
exactly. But when you like are doing research and like really, when I was like sort of looking at the efforts, there were multiple efforts and all of them failed. I mean, there were a couple of cases in the Warrant Court that were won, and I agree that that really changes the course of things. But the cases that were brought to either try to pursue accountability for, I mean, torture is a crime. It's an international crime. It's a gross crime. It's a crime under U.S. law. So when there were efforts to prosecute or rather sue in U.S. courts, those people who were responsible for the torture program, or to pursue justice for victims of U.S. torture. The courts, it wasn't that the courts said, oh, torture is fine, but what every single one of those cases failed for reasons that are, tied into how the U.S. legal system works. In other words, that, certain people, who are trying to sue the government would lack standing, or that the issue is a political issue that's non-justiciable. So the courts basically didn't weigh in on some of the questions, like are these interrogation tactics a violation of the law? They basically dismissed the lawsuit so that the cases couldn't even be argued. So in some ways, what the kind of policies the Bush administration instituted, even though the torture policy is over, our legal system has been so damaged because there was never a legal cleanup. There was the lawyers I write about stopped certain things through their legal challenges, but there's been no, significant cleanup. I mean, I would say that's not completely true. I mean, the military did, and with the sort of active involvement of the late Senator John McCain, who was himself a torture victim from the Vietnam War. He once he came to understand in 2004 and 2005 what had been authorized for military interrogators, he basically passed got an amendment and passed a law, and it's now been instituted, basically taking the military out of the coercive interrogation business. So the
Yeah, but he
military has cleaned up
didn't
its house of
apply it to the CIA, right?
right. Well, the CIA is beyond hope. So, but I
Sure,
think
but
that
if
the CIA, I think the
this
CIA
is
did
another
learn its
example,
lesson.
though, of where if you could just move the deck chairs, if an administration wants to move to, just doesn't want to have the military do it, have
Right.
someone else do it, then
Right.
that's kind of what they were doing with black sites.
Mhm.
And then I think one other thing about indeterminacy I wanted to ask is, while it may be true that torture is non-negotiable as a concept, what constitutes torture seems to still be a movable feast, or at least to the, as you called them, far right lawyers, it was a movable feast. And essentially they said whatever we're doing doesn't meet what torture, the definition of torture is.
Right. I
Uh,
mean, that particular, like the tail of that memo goes back to, John Yoo, as I mentioned, who, by the way, is a distinguished professor at Berkeley Law School,
of all
now.
places.
Yeah, exactly. So what John Yoo did, and I'm sure he, had other people sort of weighing in on this as well, but in order to basically provide legal cover for those re-engineered seer techniques, he basically are, conceded the idea that torture is a vague concept. Like, what does it mean? When the United States ratified the Convention Against Torture, they did provide certain kinds of, understandings, like how the convention would be interpreted in the United States. And so basically, the way in which, the definition of torture was intentionally causing severe physical pain or prolonged mental harm. So then, John, you basically just said, well, what constitutes severe physical pain? And then just, basically argued that the kinds of things that US CIA interrogators wanted to do did not rise to that level, because the way in which he defined it was severe mental pain is equivalent to pain comparable to organ failure or even death. So any pain that would be less than that would be not torture. And if it's not torture, it's not illegal, which also ignores the fact that cruel, inhumane, and degrading treatment is also illegal. But, so you get these people who were pursuing their own ideological wish fantasies, but they had the role of being government lawyers in the Office of Legal Counsel. And so when they write this crazy nonsense in memos, it actually has the function of law, because Office of Legal Counsel memos are supposed to be like the OLC is the government's lawyer.
So let's, for a second, I'm going to try to put my hat on like I'm at least trying to see things from their perspective, which is very hard for me to do. It's not really, where I'm at.
You'd have to have a lobotomy.
Yeah, there are two sides to this, though. There are the people who did nothing wrong, who were arrested and tortured, a lot more of them than the other kind. And then there's the people who were at least theoretically involved in terrorism and were tortured to get information. But it doesn't seem like these justifications address the kind of moral cost of arresting a lot of people and torturing them who didn't do anything. Was there, in any point of this, does the Bush administration or any of their people or organs or whatever make any concessions to the fact that they might have harmed innocent people?
Oh, well, no. There's never been any, official apology. The kind of closest the government came was in 2014 when President Obama was like, "Oh, we did a lot of things right, but we tortured some folks." That's like hardly an accounting. But the living, enduring proof of the damage that torture did to the very interests the United States government claims to be defending is the fact that the 9/11 case, which involves 5 people who are accused of having played various roles in the planning of 9/11. One of whom is Khalid Sheikh Mohammed, who is the alleged mastermind of 9/11. He and the other 4 were held along with others in the CIA black sites for years. And then when the Supreme Court issued a ruling brought by a military lawyer that challenged the government in the case of Hamdan v. Rumsfeld, that case was decided by the Supreme Court in June of 2006. And the Supreme Court said, guess what? Common Article 3 of the Geneva Conventions applies to everyone in U.S. custody. And so it was that decision in 2006 that forced the Bush administration reluctantly to empty the black sites. And so then they brought 14 people, including Khalid Sheikh Mohammed and the other 4 people who are charged with responsibility for 9/11 to Guantanamo. And then they tried to put them on trial. That case, 9/11 happened in 2001. It's 2023. That case was stuck in pretrial. First of all, it failed once. It collapsed, and then it was they were rearranged in 2012. And for 20 years, the case was in pretrial pretrial status because of the fact that they had been tortured by the CIA. So that the government that tortured them, is seeking to execute them. And, it's just, that was a failure. Now that case is involved in plea bargain negotiations. And so if the government had wanted to actually try and execute people responsible to prove them, guilty in a court of law, they completely screwed themselves by, having tortured them. But this goes back to Cheney. This goes back to Cheney's, ignorance and hubris. He believed that whoever the CIA had, those people would never see the light of day again. The idea was almost like this is where we come back to the Phoenix program scenario. Like you're going to torture the hell out of them, get whatever information you can, and then just permanently disappear them, meaning kill them or whatever. And it was really, a shock when, like the people who, you get these 14 people who were transferred from CIA custody to Guantanamo in 2006, and like now the CIA is on the hook for what they did with these people. But that it was that transition, and this is one thing I don't go into detail in my book, but I begin with the argument. The reason the U.S. government's strategic approach to the war on terror shifts from capture, interrogation, and detention to targeted killing, that is extrajudicial execution, was because of the fact that they could no longer hold people, disappear people, and torture people, in secret because of these various legal cases that had kind of precluded those options. And so then, targeted killing escalates in Bush's last year in office and then expands exponentially under Obama and then continues under Trump.
I remember reading the Senate report when it came out, and you talked about this a little bit already, but one of the conclusions was that information gained through torture is pretty close to entirely unreliable. I think that's correct. Is that,
Yes.
are
Yes.
we likely? I mean, I know that the story even you mentioned in the book is the classic ticking time bomb
Mhm.
that, was kind of the premise of the whole series 24.
Mhm.
Uh, are we likely to ever gain the code from anything like? I'm playing devil's advocate to some extent through torture. Is there any evidence that suggests that torture is effective?
No, absolutely not. If you don't know the answer, or if you're not able to get someone to offer a true answer, and you do that through rapport building techniques or other like lawful interrogation techniques, if you don't know what the answer is, people can say anything. And that's what the CIA torture program proved, was that like so many false statements were made under torture, and then the government didn't know whether those were true or false. Like, there's plans to blow up the Brooklyn Bridge, or Al Qaeda is converting Black Muslims in Montana. It's like Black Muslims in Montana. I mean, but like then they'd send off people to try and investigate these things that came out as a result of torture. And there was, the CIA, I mean, the Senate Select Committee's report really documents that there was nothing that came out of positive nature of the CIA torture program, and many, damaging and harmful things were the result of that torture program.
And one of the harmful things I think is that the signal we send by doing this tells the rest of the people in other countries, in essence, that that's fair game, right? I mean, it puts our citizens and soldiers at risk in the same way that their citizens and soldiers were put at risk. Is that fair, or is there any deterrent value?
That's absolutely fair. This is why JAGs, Judge Advocate Generals, when they found out what was happening, it was a kind of the secret clandestine move to authorize torture. And then also then when John McCain, who was in the Armed Services Committee, which is responsible for the well-being of the military, they realized that, this would be extraordinarily dangerous to U.S. soldiers in future wars. It would also, but one thing that was learned from, the lessons of Vietnam that Cheney obviously took the wrong lessons from, was when, a military is fighting without abiding by laws and rules, it causes chaos and dissension in the ranks. I mean, like the phenomenon of fragging during the Vietnam War, where like, soldiers would basically kill their commanding officers, because it's like if there's no rules and everybody can, be killed, and there's no sort of sense of what the limits are or what the guidelines are, it actually degrades the military itself. So it was like pure damage. And anybody, and this is one of the things, like I'm not, I mean, I believe there are many issues in life where indeterminacy applies, but I basically feel that anybody who thinks that torture works is an idiot, doesn't know what they're talking about, has not paid attention, lacks the basic ability to discern reality from fantasy. And so this is one of those things where I feel like we are standing on very solid ground with this one.
So we get no actionable intelligence.
Mhm.
There's, if anything, it puts our citizens and soldiers at risk abroad. And on top of that, there were a lot of innocent people. I mean, of the, we talked about, you said earlier, like tens of thousands of people, approximately how many of those people who were detained and tortured or interrogated, whatever they want to call it, were actually factually innocent. It was a fairly large percent, yes?
Right. Yeah, I mean, absolutely, because what happened at the beginning of the war on terror, the United States didn't know who was who or what was what, and so they're in Afghanistan, and people like the government was, the military was offering massive bounties, and so people would like turn in their enemies like that, this guy, his, sheep were eating my grass and I'm going to like turn him in, so anybody who ended up in interrogation in Afghanistan at the beginning of the war, was presumptively, you know, a terrorist. That was sort of what the interrogators were told was like, presume that these people are lying to you. Presume that if they land in Bagram, despite the fact that they were sold for bounty or whatever, that they're going to be guilty. And then decisions were made in Washington very early on when Guantanamo was selected to decide that every non-Afghan who was captured in Afghanistan would be sent to Guantanamo. And the presumption, again, hubristic ignorance, was that the only reason foreigners would be in that country was because they were terrorists. And so every non-Afghan, plus then lots of Afghans who were like members of the Taliban, et cetera. But, first of all, some of the people that, were characterized by the government as like these high value detainees. It's one thing, but then to then try and prosecute them in a military commission, the government had to completely reinvent the idea. There's a very basic and utterly ludicrous, and we can see this happening with the fate of the military commissions. The idea that non-soldiers can be prosecuted for violations of the laws of war. That, first of all, is crazy because non-soldiers are not subject to the laws of war. But then also turning non-war crime offenses into violations of the laws of war in order to prosecute them in the military commission. So turning conspiracy into a military offense, or turning, whatever, attempted murder. It's like, war crimes are like, that's not what a war crime is.
Yeah, but this was just another attempt of them to stop them being in regular courts, right?
Right, absolutely, because they'd all been tortured. But it's like the military commissions, in totality, the cases that have survived are two. In 20 years. Like several of the cases, there were only like 3 cases were prosecuted during Bush's time in office. I think 6 or 7 were prosecuted in Obama's. Every single one of them, except one case, that was actually thrown out once the appeals court got to weigh in, like in 2016 and 17, and said, yeah, you know what, these things are not actually prosecutable offenses, and so those sentences were vacated. So the whole thing has been just one giant waste of time, and so, but coming back to your question about like people who are innocent, so one Hamdan, the guy Salim Hamdan, whose case, sort of ends, brings an end to the torture program. He was, some poor Yemeni who'd gone to Afghanistan, as many people would do, because his brother-in-law had encouraged him to go there, and his brother-in-law gets him a job as Osama bin Laden's driver. He's like, a poor guy driving. He gets captured after 9/11 in, November of 2001. And then it's like they turn him in, the government, when they want to prosecute him in the military commissions, turn him into this terrorist mastermind. The prosecution attempted to like link this Yemeni guy, Salim Hamdan, to 9/11 and the 1998 Al-Qaeda bombings of embassies in Africa. And it failed. The military jury that ruled on his case basically, was like, no, we don't think so. Maybe one, they gave him, one charge, they convicted him on one charge of material support for terrorism, which isn't a war crime, and, found him not guilty of all the other charges.
You were present for some of the legal proceedings. And I have to ask, because I don't know if I'll ever get to talk to anyone else who was involved, although I guess in a sense, one of the lawyers you talk about, I do know. What were some of the most surreal moments for you? It had to have at times been very strange.
Right. Well, so let me say that, when I, just to put this in context, because the book is my book, The War on Court, is written really in the first person, because like I'm sort of writing about sort of going there. And so I started, as soon as like these legal challenges started, I started interviewing lawyers. And once lawyers started going to Guantanamo as habeas counsel, I would interview them, but I couldn't, or I assumed I couldn't go to Guantanamo. Like I couldn't write a National Science Foundation grant. Like I would like $30,000 in order to go and conduct research on what's happening at Guantanamo. But it was only and I was very frustrated. So my research was all based on like just interviews with people out of one of the contexts I was studying. And then in 2010, I was really frustrated because that was Obama, the first person that the Obama administration decided to prosecute was a child soldier, sort of breaking global tradition of not prosecuting child soldiers since World War II. And so a friend of mine who was an expert witness for the case of Omar Khadr, we were talking before one of the hearings, and I was like, oh, I wish I could go. And she said, well, you could go if you went as a journalist. So I was like, ding, I write journalistically. And so that was like really the opening for me to be able to go to Guantanamo. I go as a journalist. And I do write journalistically. But I would say so I was there for the last 3 hearings of the Omar Khadr case, but and then most of the other cases since 2013 that I've been to Guantanamo 14 times. So most of those trips were to observe and report on the 9/11 case. And I'll tell you, like the 9/11 case, I mean, as I said, it's been going on for years. But one thing that happens is every time there was a hearing, there would be journalists who would come down, NGO observers, and then they would also victims. Like the family members of victims of 9/11, there's a lottery that they could like put in a bid to be able to go down and just be observers of the case. So there's always the victim family members, along with the journalists and NGO observers sitting in the gallery, the soundproofed gallery in the back. And so one of the, just perhaps the one event that really comes to mind about the strangest moment was when the lawyer for Khalid Sheikh Mohammed, and he's like the icon of both 9/11 because he's the alleged mastermind, and the CIA torture program because he was waterboarded 183 times. I mean, his treatment was the most intense. So, one of Khalid Sheikh Mohammed's lawyers was basically talking about the brain scan that they had conducted on him and the other people. There was an MRI machine had been brought to Guantanamo, and this lawyer, Gary Sower, the lead counsel, was saying that there's evidence that Mohammed suffered brain damage as a result of his treatment in the black sites because he'd been walled repeatedly. And in fact, that was one of the things that when Mitchell testified, he said that the only thing that really worked on Khalid Sheikh Mohammed was walling him. And so then the lawyer is making the connection between what the CIA did to Khalid Sheikh Mohammed, and he says, and this might force the government to take the death penalty off the table or even throw out the charges because of outrageous government treatment. And all the victim family members were like, because this is the guy that for those who endorsed, the death penalty, hearing that their aspiration to see, the person who haunts their nightmares getting off because the government tortured him, that was like a shocking moment, for people.
And, in your own experience, though, like I think about like when I was incarcerated, it became very clear to me how thin the line really is sometimes between kind of what we see as our free life and the life can quickly turn into incarceration, or in this instance torture or military disappearance or things like that. Did you ever have moments when you were going through like security and things like that where you kind of saw the thinness of that line in that way?
I mean, for me personally, no. Like, I would say, like, sort of having cut my teeth in Israel, Palestine, like, it takes a lot to really get me scared, like, I don't really
Well,
have.
I'm not even saying scary as much as just that they're, that you can
Right. Oh, you can
how,
see it. But the only thing I would say is I can see it for other people, but at least vis-a-vis going to Guantanamo, it's rather than that thin line. I mean, the worst thing that can happen to a journalist is if they do something that violates the rules and then they can get shipped off the island. I mean, like really the worst thing that would happen. But it's a very infantilizing, like the way in which journalists are, they're sort of, they have their minders, and they, everything is sort of, it's like, being under surveillance. But I personally didn't find for myself any kind of, sort of danger. And the one thing I would say, and I just really want to give a shout out to, Carol Rosenberg, who's been reporting on Guantanamo since those first, people were flown in on January 11th, 2002, and she's still, down there for every military commission hearing. I mean, she has, like, everything, almost everything we know about Guantanamo, especially in the more recent years when media coverage has dissipated, we know because Carol Rosenberg reported it. And she has, like, learned so much and is such a master of what is permissible, what's not permissible, and that she'll push the line. So, like, having, being on a media delegation with Carol Rosenberg is like having a white knight, guarding you along the way.
So even early on, we saw some domestic application of these ideas. There was the case of Ashcroft versus Iqbal. House, I know they've moved on, which is arguably not a good thing, but certainly not a good thing to the people who are targets, many of whom are civilians, but to targeted executions. How safe, though, should people in this country feel? And are there precedents that could be applied domestically in other ways? Like, for instance, in the case of the Ashcroft versus Iqbal, someone was, it was a foreign national, but was, a lot of these techniques were used in a regular federal facility, is my understanding. Do you think there's any overlap or anything bled from the?
Well, I think that, the kind of extra legal violence that police interrogators might use, or, any other, like, domestic security forces, to utilize the kind of tactics that were authorized for offshore interrogations has to be done extra legally, at least now. But it does happen. In the sense that police, like, for example, the scandal of 22 decades of Chicago police torture, that kind of a thing. Like, those tactics. What happens then is that the violent and illegal and brutal techniques that might be used are not necessarily legal, but if the system is incapable of holding people criminally accountable for those things, then for all intents and purposes, it's de facto legal. So there's a lot of, like, de facto legalism. I just think, that the damage that was done to kind of just assert the government's right to do the things that were done in the war on terror has emboldened people like Donald Trump and others to feel as though the executive branch should be, unfettered by, oversight and so on. So many of the contemporary domestic travails that this country is going through are kind of can trace their roots back to the immediate, the policy and legal developments of the war on terror. And the war on terror isn't over as long as Guantanamo is open. And one of the reasons Guantanamo continues to be open and must stay open is because Congress passed legislation in 2010 or 11, basically barring any person who's ever been at Guantanamo, including those who are still at Guantanamo, from coming into the United States for any reason whatsoever, including trial or detention. And so, and the reason why they're in Guantanamo is because what was done to them would never fly in the United States. And even if Congress lifted that thing, what was done to the people who remain at Guantanamo, the 35 people, and there's only about 11 of them that are slated for military, the 5/9/11 people and a few others who are slated for prosecution, is because they couldn't be tried in federal courts because of what the government did to them. There's federal, standards and so on. So it's just a very messy and unresolved set of issues that I feel that people, this is one thing I try to argue, in the book, is just to have people really understand with a sense of clarity and a broad view of what actually happened, how the law or lawyers responded, or how the courts did or failed to respond in certain ways, in order, like, if there is another in the future, another occasion when there might be the temptation to just like throw all legal standards and norms to the wind in order to justify, security policies that are flatly illegal, that maybe this book might be, sort of one of the resources people would look to say, oh yeah, we really shouldn't go down that road because it was a disaster when we tried it last time.
Yeah, I know we struggle a lot with similar pressures in the criminal justice world, where, like you're talking about, something just terrible happens. There's an anecdotal, terrible, something really bad happens, and people kind of immediately move past what everyone maybe thought were core principles, and in the rush to kind of a brutal response to try to get justice or information or whatever it is. After studying all of this, have you come to any conclusions about the way we can or should counteract these kind of impulses, which seem somewhat natural because they happen over and over and over again? You can see them through history, where something terrible happens, people essentially throw their principles out the window, and then we have to deal with situations like this.
Yeah. I mean, it raises like, this is something that I've really struggled with as a citizen, and also as a scholar in terms of dealing with these kind of issues. But, there are aspects of like US American political culture, and we see them playing out now where, it's, very vivid with like, there is no longer like our consensus opinions about what is true, or like even the idea that human beings deserve certain kinds of, that was a long fought, centuries long battle to just recognize the humanity of humans, and that was so easily dissipated with sort of the surges of anti-immigrant rhetoric, and the fact that like a significant portion of Americans now would bemoan the cancellation of the torture program and would like to have it restored, and so on. So we have like something like torture or all of these contra legal policies, they, to the extent that they are authorized by governments and endorsed by influential figures, be they politicians or pundits, it seeds support for them within society. And our society is so, sort of at odds with itself over what is true, what is right, what is necessary, that, it's like torture is just a manifestation of a different problem, in American society that goes much more deeply into what's wrong with us.
So let me try a different way at seeing if there's a solution. You conclude the book suggesting that the law might not be enough, and for torture and other things that were like what we're talking about to never happen again, we would have to have a political reckoning. Do you have any theories about how people might be moved to put things like human rights before exceptionalism? How do we have that political reckoning?
Well, it's like I like it. I think I say this in my book, or at least I think it is like a theme. Is that education, knowledge, and understanding are vital, and so for people to educate themselves and understand, history, so it doesn't repeat itself, or understand. I think that education is absolutely crucial, and it is for that reason that education is seen by those who don't want to accept realities or complex truths, etc., why education is in the crosshairs. And so I mean, if one just even looks at, for example, the assault on what right wingers think critical race theory is, it's like critical race theory emanates out of a kind of legal rationale of like the structures and legal processes that have entrenched and sustained, even as they've altered kind of racial disparities in society. Not a radical position, and kind of empirically obvious, but like having that
One would think
become
empirically obvious, and we've discussed CRT many times,
right. But
including
it's like the fact that this is like in the
on the podcast.
crosshairs of people who are literally anti-intellectual. And so one way I think about it is like it's like the intellectuals versus the anti-intellectuals. And so people should just like be intellectuals because that is what I think is crucial for at least pushing back against the most horrific and ignorant policies and practices.
I mean, I agree with you in a sense, but I'm not sure that the most effective political strategy is to say okay, all of you who disagree with us, you're anti-intellectuals and we're the intellectuals, you
Well, I
know.
mean, it's yeah. I think it's like, how does one? I mean, even if we take the simple issue, or more simple issue of like critical race theory, like you see people basically on the news who are like, experts on critical race theory talking about what it is, and then you see people who are combating them, making up things. So it's like that's true. I mean, I'm not a politician, so I
No,
don't
I got
really
it.
have
I just
the political solutions, but I do feel that education, knowledge, awareness, sort of realistically grounded consciousness. Those are all, essential tools for a functioning democracy.
yeah, one would think so. And I mean, I push people on these kind of questions not because I think that there's necessarily an obvious answer, because if there were, we wouldn't be in the situations we're
Yeah,
in, but just to
yeah.
see what people come up with. Um, I always like to ask people if there's any kind of criminal justice or criminal justice adjacent books that they might like and recommend to our listeners. Do you have any favorite books aside from obviously your own book, which you can feel free to plug again?
Oh yes. Well, yeah. So I hope that people will, pick up my book. It's called The War in Court: Inside the Long Fight Against Torture. And if you actually go to my Twitter, it's just at Lisa Hajjar. The pinned tweet at the top has a code, so you can order the book through University of California Press for a 30% discount. But it is, I mean, one thing I say, like, this is based on 20 years of research. I don't think there's any book that does what I do. I mean, it's really a 20-year accounting of what happened in the course of the war on terror around issues
And
of
just
interrogation.
so people know, I was trying to get major themes, but you do a pretty exhaustive kind of like timeline from the very beginning to the end of going through all of the legal challenges and what happened. And I think that's very, I think if I tried to go that route, it would have been like a 4-hour interview. But
Yeah. Well, this is why it took me 20 years to write the book. But I mean, the books I would recommend, I mean, one of them, I mean, it's just such a powerful book, is written by a former Guantanamo detainee, Mohamedou Ould Salahi. And so while he was still imprisoned, his lawyers, it took them years. They had to fight the government in court for years to get his letters to them cleared. And they were heavily censored. But while he was still at Guantanamo, his book was published. It's called Guantanamo Diary, which really is just, I mean, he is a beautiful writer. He's authored many other books. He was finally repatriated back to Mauritania. And then he and the guy, Larry Seames, who had worked with him on the first, or who had worked on the first book, they joined forces. Larry Seames is the director, or one of the directors of PEN, the Writers Associate for Freedom of Speech. And so they issued in 2017 Guantanamo Diary Restored Edition, in which they basically filled in all the stuff that had been redacted in the earlier version. And the perfect complement to that, I mean, really, like I love movies. I see every movie ever made, but the best war on terror movie is the movie based on Salahi's life, The Mauritanian. And so Jodie Foster plays Salahi's lawyer, Nancy Hollander, and Benedict Cumberbatch plays the military prosecutor who was, assigned to prosecute Salahi, and then comes to realize how brutally Salahi was tortured, and the case falls apart. But The Mauritanian is absolutely a fantastic movie, and Tariq Rahim plays Salahi. And then another book by another Guantanamo detainee who now is living in Serbia. It's Mansour Adayfi. We don't forget us here. That's Mansour Adayfi's account. And what makes Adayfi's autobiography so interesting is he really writes about Guantanamo as a place, like the detention facility. And it's really, I mean, I know that, a couple of my political geography friends found that book interesting just because of the kind of geographical imagery that he's able to capture. And it's also beautifully written. And then the fourth book I would recommend to people is written by the late, great Michael Ratner. It's his autobiography that was published posthumously, called Moving the Bar: My Life as a Radical Lawyer. And so excuse me, that's a really powerful autobiography. And, Ratner, was at it from the Attica Rebellion up to, the fights against torture at Guantanamo. So his life is a very eventful one.
I always ask the same last question. What did I mess up? What question should I have asked but did not? There doesn't have to be an answer to that, but if you have one, I always like to hear what people would have liked to talk about that I missed, if that's...
Oh, I think, well, hopefully, your listeners will get a little bit of a sense. I mean, the one thing I would simply add is that, I think, and maybe you can agree or disagree, like that the book is it's written in a style like of stories, so it's not, I mean, while we're talking about these complex issues like unfettered executive power, there's a lot of people, there's a lot of characters in the book, a lot of the happiness and the tragedies that affect them in this. So I think that's something that I hope.
Yeah, it's definitely not a dry read. It's definitely there's a lot of life in there.
Right. So that's it. I think it's been a pleasure talking with you.
Thanks so much. It was a great pleasure to have you on the podcast. Thanks so much for listening to the Decarceration Nation podcast. You can learn more about this episode in the notes or visit our website, www.decarcerationnation.com. If you enjoyed the podcast, please subscribe and please like this episode and leave comments below. Special thanks to Andrew Stein, who does the editing and post-production for me, to Ann Espo for helping with our transcripts and social media images, and to Alex Mayo, who helps with our website and does the video transcription. Make sure and add us on social media and share our posts across your network. Also, thanks to my employer, Safe and Just Michigan, for helping to support the Decarceration Nation podcast. Thanks so much for listening to the Decarceration Nation podcast. See you next time.